Hello, everyone, and welcome back from break. Thank you for joining us today during our symposium, The Deadly Intersection of White Supremacy and Guns. Our next panel brings together legal experts to discuss white supremacy and firearms within the context of the Constitution and its history. In the Supreme Court's recent Bruen decision, which dramatically expands Second Amendment rights, Justice Clarence Thomas directs our constitutional attention to the past and focuses on our history of white supremacy and oppression and the claims that expanded gun rights undercuts white supremacy. That claim, however, understates the use of gun regulation to fight white supremacy, understates the use of guns to further white supremacy, and raises hard questions about what history the court treats as binding and what it treats as cautionary. Ultimately, the court's rhetoric and legal holdings threaten to privilege guns over community self-defense and the preservation of the public sphere. Experts in this last panel will discuss how racial hierarchy affects disclosures from the legitimacy of armed political violence, the deadly interplay of free speech and gun rights, and recent events that have created the potential for political violence that puts the U.S. democracy at risk. Tim, now over to you.
Greetings all. My name is Tim Carey, and I am the Law and Policy Advisor at the Center for Gun Violence Solutions at the Johns Hopkins Bloomberg School of Public Health. I thank you all for joining me for a critical discussion that has ramifications for civil rights, public health and safety, and the very foundations of our democracy. I have the privilege of moderating this panel of issue area experts to guide us through a conversation about the relationships between race, gun violence, and the Second Amendment. The United States' relationship with guns is an exceptional one. Not only does our country have the highest number of gun-related deaths and injuries among high-income nations, but it also has the strongest legal protections for firearm possession and use. The Supreme Court recently expanded these protections in last summer's case, New York State Rifle and Pistol Association, or NYSRPA, v. Bruen, where the court recognized the constitutional right to carry firearms outside of the home for self-defense for the first time, and fundamentally altered how courts can decide Second Amendment cases. When lower courts could initially consider how gun violence prevention laws serve important government interests, such as public health and safety, when deciding whether to uphold these laws, courts are now forced to limit their analyses to comparing modern-day laws to historical regulations around the 18th and 19th centuries. This dramatic shift has perplexed courts, legislators, and experts alike. Never has the Second Amendment space been as uncertain as it is today. At the same time, the court is making it more difficult to regulate guns in public spaces. Guns are reaping dramatic tolls on human life and social stability. Mass shootings in Charleston and Buffalo come readily to mind, as well as the white supremacist views of paramilitary extremist groups that have become emboldened by increasingly violent political rhetoric. Our conversation today will first explore the interactions, contentions between the freedom of speech and the right to bear arms. It will then transition to a historical and contemporary look at the Second Amendment and its relationship with race. And last, we will learn of the current Second Amendment legal landscape and what it means for racial justice and the preservation of democracy. We will conclude our time together with a robust question and answer session with the panelists. We have a phenomenal lineup of panelists that I will briefly introduce. Each panelist will provide their remarks before opening the conversation up for questions from the audience. And audience members are encouraged to email their questions to cgvs@jhu.edu. And first, we have Greg Magarian. Gregory P. Magarian is a professor of law at the Washington University School of Law in St. Louis. His first book, Managed Speech, The Robert Court's First Amendment, was published in 2017 by Oxford University Press. His expertise focuses on constitutional law issues related to freedom of expression. And we have Daryl Miller. Daryl A.H. Miller is the Melvin G. Shim Professor of Law at Duke Law School and the faculty co-director of the Duke Center for Firearms Law. He writes and teaches in the areas of civil rights, constitutional law, civil procedure, state and local government law, and legal history. With Joseph Blocher, he's the author of The Positive Second Amendment: Rights, Regulation, and the Future of Heller. Joseph Blocher and Reva Siegel will be jointly presenting today. Joseph is the Lanty L. Smith 67 Professor of Law at Duke Law School, where he, along with Daryl Miller, also co-directs the Duke Center for Firearms Law. And Professor Reva Siegel is the Nicholas Katzenbach Professor of Law at Yale Law School. She has written extensively in the areas of constitutional law and civil rights on questions of equality on the basis of race, gender, and sexual orientation, as well as liberties, including gun rights and their regulation. Now, with this foundation laid, we'll turn to our panelists, starting with Greg.
Well, Tim, thank you. And I want to thank everyone at the Bloomberg School who has been responsible for putting together this terrific symposium and including us in it. I want to talk today about my angle into an interest in Second Amendment law and gun rights comes from my base as a scholar of First Amendment law. And I want to talk today about a chapter in a book that I'm working on. The tentative title of the chapter is The Alchemy of Speech and Guns. And just by way of a little bit of background, the idea of the book is to examine from a lot of different angles the relationship between First and Second Amendment rights, between free speech claims and gun rights claims. And there are important ways in which the First and Second Amendments operate at odds with one another. So a very prominent example is a lot of the recent debate and discussion about armed protest and the way in which guns in public spaces can turn political protests into sort of deadly and intimidating events. But I want to talk about a disturbing sense in which the First and Second Amendments operate together and in coordination with one another. And this is what I call the alchemy of speech and guns, the way in which the joint exercise or availability of First Amendment rights and Second Amendment rights results in deadly identity bias oriented violence. So to begin, and Tim, you were alluding to some of these instances a couple of minutes ago, we are experiencing an epidemic over the past 15 years or so in our country of what I'll just call hate shootings. Shootings motivated by one or another kind of identity bias, most commonly white supremacism. You mentioned Buffalo and Charleston, but also anti-Semitism at the Tree of Life Synagogue in Pittsburgh, misogyny in the UC Santa Barbara shootings. And all of these instances have, I think, two important elements in common. One, obviously, is the use of firearms and the easy availability of firearms that makes these deadly massacres possible. But the other common element is the importance of First Amendment rights and free speech in creating the preconditions for these violent actions. In all of the shootings that I just alluded to, the shooters were radicalized or involved in radical communities online. Their hateful identity biases are really easy to trace through their record of essentially First Amendment activity. And so this is what I call the alchemy of speech and guns, the way in which these two rights exercised together combine to create these awful massacres. And by the way, the emphasis on hate shooting, on mass shootings, should not be understood to sort of understate the range of other more individualized one-on-one instances, a lot of which we don't really hear about. But as in any kind of study of gun violence, the emphasis on mass shootings is sort of an easy thing to point to, but even more problematic are a lot of the smaller events and the massacres of or shootings of Ahmaud Arbery, Trayvon Martin give good, just tip of the iceberg of events other than mass shootings that fit into this picture as well. So I want to talk about this phenomenon from sort of where I come from in First Amendment law. And I actually want to go back to the beginning of First Amendment law, which just goes back about 100 years, and talk about something I call the assumption of rational intermediation. This is an idea that is foundational to First Amendment law, and it's foundational to the sort of proud First Amendment tradition of protecting even extremist radical political ideas from government interference. So basically, this assumption of rational intermediation says that we assume that public discussion, public discourse can effectively mediate between ideas and actions, can, in other words, prevent arguably radical, extremist, dangerous ideas from being transmuted into actual dangerous conduct. And if you go back to the very beginning, if folks in the audience know nothing else about First Amendment law, you probably heard the phrase the marketplace of ideas. And this goes back to an opinion by Justice Oliver Wendell Holmes in one of the very first First Amendment cases that the Supreme Court heard, where Holmes said, the best test of any argument, of any idea, is its ability to make itself known and prevail in the marketplace. That is how we use free speech to pursue truth. And in a few years after that, Holmes' sort of comrade in arms at this time, Justice Louis Brandeis, came down with an equally influential formulation in a concurring opinion in a case called Whitney versus California, where Brandeis said, open public debate is essential for democracy, and the only circumstance in which we should allow government to restrict speech is if there's no possibility for further conversation to disprove or derail dangerous ideas. Only in an emergency, Brandeis said, should we allow suppression of speech. And both of these Holmes and Brandeis formulations, I think, partake of this idea of the assumption of rational intermediation, the idea that the way free speech works is to rationally work through ideas and arrive at what we hope will be constructive and socially beneficial outcomes. Now, this idea is, as I said, foundational to First Amendment law and foundational especially to the First Amendment commitment to protect radical political ideas, but it's not always an assumption that has been honored in the breach. Just a couple of decades after those famous Holmes and Brandeis opinions, the U.S. Supreme Court handed down a decision called Dennis versus United States in 1950. This was a case involving federal prosecution of the leaders of the U.S. Communist Party. And essentially, these communist leaders were not engaged in any sort of active, violent conspiracy. They were being prosecuted for advocating and teaching ideas in Marxist-Leninist doctrine, which include the idea that it is just and desirable, if necessary, to violently overthrow capitalist governments. And in the Dennis opinions, it's striking how the majority justices reject the assumption of rational intermediation. How they say the international communist conspiracy is something that can instantly transmute ideas into action. There is no opportunity for further discussion. We have to nip this terrible conspiracy in the bud. Well, if that sounds a little bit quaint going back to 1950, there's a more recent iteration of roughly the same idea dealing with the more contemporary problem of global terrorism. 2010, the Supreme Court decides a case called Holder versus Humanitarian Law Project. And in this case, a group of peace advocates essentially wanted to engage in dialogue with some groups, the Tamil Tigers in Sri Lanka and the Kurdistan Workers' Party, who had been identified by the State Department as global terrorist organizations. Essentially, these peace advocates said, we want to talk to these terrorist groups and teach them how to work and play well with others and to achieve their goals through nonviolent means rather than violent terrorism. And the Supreme Court in the Holder versus Humanitarian Law Project decision essentially said it was okay for the government to stop this communication from happening. And what Chief Justice Roberts said in his majority opinion in this case was essentially that these peace organizations were naive dupes, that, of course, global terrorist organizations can essentially instantly transmute bad ideas into dangerous actions. So in this context of sort of global geopolitical threats, the Supreme Court has often been wary of the assumption of rational intermediation. Well, there's another important, different doctrinal setting in Supreme Court, in First Amendment law, that puts a different kind of strain on the assumption of rational intermediation, and that's hate speech. Which brings us around closer to the immediate topic of today's discussion. Hate speech as we commonly understand it, is not a term of art in First Amendment law. The Supreme Court hasn't recognized a category of hate speech, but it certainly dealt with a lot of cases involving hate speech. And from those cases and from our experience, we can see some ways in which hate speech puts a distinctive kind of pressure on the assumption of rational intermediation. Hateful ideologies often seem to operate not through any means of rational persuasion, but by appealing directly to prejudices and passions, bypassing the rational faculties in a lot of ways. Another important thing to recognize about hate speech is that unlike any of the geopolitical threats that the Supreme Court has been so concerned with, the costs of hate speech are not spread evenly across society. If the international communist conspiracy is going to overthrow the United States government, that's a cost or a danger that we're all going to bear commonly and equally. But the costs of hate speech are imposed in a concentrated way on particular populations and on particularly vulnerable populations that are probably least well situated among others in society to have to bear the cost of that we attach to free speech. And on top of all of that, the problems of hate speech are exacerbated in our current context by online communication, by the ease and speed and breadth with which hateful ideas and ideologies um, can be propagated and circulated. So we see the Supreme Court in these geopolitical threat cases being wary of the assumption of rational intermediation. We see in the problem of hate speech a different and in some ways more serious kind of strain on the assumption of rational intermediation. And yet, despite all of this, the assumption of rational intermediation has been very robust and very resilient. And I think there are a couple of reasons for that. One is that the assumption of rational intermediation is literally necessary for a regime of constitutional speech protection. You really can't have First Amendment law, First Amendment protection without the assumption, even if it's a not always correct assumption, that public discourse operates in a rational way that mediates between ideas and action. And the other thing that we can say about the assumption of rational intermediation is that it is not only something that protects global communists and terrorists and racists. It's also an idea that has beneficent iteration. So the assumption of rational intermediation protects other kinds of radical or outlier political ideas, including civil rights advocacy in the 60s, the most obvious example. Other kinds of more constructive, radical political expression. So the assumption of rational intermediation is essential, it's beneficent, it's problematic, and it is sometimes something that provides protection for more dangerous ideas. But it is, as I said, resilient and has held up pretty well over time. And First Amendment advocates tend to look at cases like Dennis and Humanitarian Law Project and say, these are bad decisions. These are cases in which the Supreme Court wrongly gave up on or lost faith in the assumption of rational intermediation. Right. All of that said brings me around finally to the topic directly of today's discussion: white supremacy, identity bias more broadly, and gun violence. And what I want to suggest is that the proliferation of guns in our society presents an altogether new kind of strain on the assumption of rational intermediation, something that we really haven't seen before in any of these other instances. What was missing ultimately in Dennis and Humanitarian Law Project was the actual means for these radical political speakers to bring about change. This is what the Supreme Court got wrong in those cases. The idea that speech or ideas would be translated directly and immediately into action. Well, the means were not present in those cases. In Dennis, the fear that the international communist conspiracy would overthrow the United States government looks naive in retrospect because it was naive, because there was no actual present way by which that was going to happen. In contrast, the epidemic that we have now of hate shootings represents a convergence of ideas and means. The radical ideas circulate and propagate and motivate these shooters to target people and groups that they hate, and the presence of guns and the easy availability of guns actually makes it possible for that to happen. So here we have an entirely new, entirely different kind of strain or pressure on the assumption of rational intermediation, because arguably here at last we find a circumstance where intermediation really isn't possible, where it is where there is an immediate danger of direct translation of radical extremist ideas into deadly action. And so it seems to me that this circumstance leaves us with three difficult options. One option is to continue to tolerate the epidemic of hate shootings. That to me seems entirely unacceptable and not viable. The second possibility is to go back on our longstanding First Amendment commitments to protecting radical, extremist, all range of political ideas. And that would be I think, tragic retrenchment of one of the proudest achievements of our liberal democracy. The third option is to abandon or abrogate our much more recent constitutional decision, the Supreme Court's much more recent constitutional decision to strongly protect gun rights. And I think you can obviously see where I'm going with this. I think that is clearly the best among the three choices, the only viable choice among the three choices. Now, we can't get, and this is the constant problem that bedevils any sort of proposal for gun regulation or for abrogating Second Amendment rights. To a substantial extent, the genie is already out of the bottle. So many guns are already out on the street that we can't hope to just eliminate the problem of gun proliferation at this late date. But if we were to get the Second Amendment essentially out of the way, there would be a lot of things that we could do. For example, we could establish strong liability regimes for anyone in the chain of sales or distribution of firearms where the weapon ends up being used in one of these hate shootings. That would create strong incentives across the chain of gun proliferation and provision and traveling of guns for people in that chain to be very scrupulous to try to make sure that their guns didn't get into the wrong hands. That's just one policy proposal. There are a lot of other possibilities. None of them are perfect. But what I'm suggesting is that this alchemy of speech and guns is a problem that we cannot ignore, and that does not, that again leaves us with these three possible choices, only one of which I think is in any way viable or appealing. So I really appreciate the opportunity to participate in this symposium. Thank you all again at Bloomberg, and thank you, Tim, for moderating the panel. And I'm really looking forward to the other panelists and to the discussion and Q&A.
Well, thank you, Professor McGarrian, for that robust look into the First Amendment law, its history, and how it interacts in present day with the Second Amendment. But to teach us more about the historical roots of the Second Amendment and how it plays out in a lot of modern contexts, specifically around race, we'll turn to Professor Daryl Miller.
So thank you very much for this opportunity to speak. The remarks that I have today come from a piece called Estoppel by Nonviolence, which I recently published in the Journal of Law and Contemporary Problems. So my piece is going to really talk about the two traditions of political change in America. There's one tradition that invokes Lexington and Concord, the Minutemen and George Washington crossing the Delaware, and the surrender at Yorktown. And this is the American tradition of political violence. This is liberty seized through the sword. The other invokes Montgomery and Selma and the Freedom Riders, the march across Edmund Pettus Bridge, the signing of the Civil Rights Act of 1964 and the Voting Rights Act of 1965. This is the American tradition of political nonviolence, freedom obtained through suffering. Now, both of these traditions find inspiration in scripture and the Declaration of Independence and in appeals to natural law. So there are two traditions of political change in America, violent and nonviolent. But one group, African Americans, have found the most success by using nonviolence, even though they, as a people, have had the most historical and moral justification to take freedom by force. And perhaps that's not so bad, for in pursuing a successful strategy committed to nonviolence, Despite every moral right to use violence, African Americans have delegitimated any lesser claim to force as a weapon in American politics. The way I like to think of it is the blood of Martin Luther King Jr. and John Lewis and Lamar Smith and Fannie Lou Hamer and Viola Liuzzo and all the other martyrs I don't have time to name. They have nourished the tree of liberty. It's their sacrifice that has supplanted the tradition of John Locke. And because of them, nonviolence sets the baseline for fundamental constitutional change in America. So let's talk about the American tradition of violence first. Mobs do a lot of dirty work during the American Revolution, as documented by historians like Robert Middlecoff and Farrah Peterson. The history of the early revolution is the spectacle of these spontaneous violence by cobblers and sailors and apprentices and adolescents. So a ship is condemned for violating British taxes, is scuttled by rioters. A Stamp Act official has his home and business besieged by ruffians. Another group of thugs ransacked the home of a lieutenant governor office for 3 hours, tearing off shingles, destroying papers, splintering furniture, and looting the silver. The instigators of the attacks, who call themselves eventually the Sons of Liberty, feel no remorse for this violence, and as the turmoil spreads across the colonies, what originally had been the work of day laborers and sort of street hooligans becomes the business of planters and businessmen and lawyers. The professionalism of violence culminating in the destruction of 90,000 pounds of tea in the Boston Harbor by men dressed as Native Americans, and the moral rectitude of this violence to resist injustice was, to these Tea Party members, apparent. Indeed, it was, in the words of the Declaration of Independence, self evident. When the first shot of the Revolutionary War is fired in Lexington, Massachusetts, between rebels who don't want to put down their arms and the British who demand them, what the Declaration calls, quote, a decent respect for the opinions of mankind requires public reasons for such violence. So Thomas Jefferson offers them in his Declaration of Independence. King George III had visited a train of abuses against the colonists: kidnapping, transportation to foreign shores, dissolution of the colonists' governing and cultural institutions, denial of trade, denial of a trial by jury, imposition of foreign law, withdrawing protection from private violence. In the political vernacular of the time, England's government had reduced the colonists to slaves, for which they had an absolute moral right to revolution. Now, roughly contemporaneously, persons of African descent in North America, actual, not rhetorical slaves, rose up to throw off their literal, not metaphorical chains. Efforts at self emancipation began within a generation of the first recorded arrival of Africans in Jamestown, Virginia in 1619. In 1712, in New York City, warriors from Africa's Gold Coast, feeling humiliated by servitude and degrading work, plotted a revolt. They armed themselves with guns and swords, and the revolutionaries set fire to a barn, ambushed the men that come to investigate. This rebellion was rapidly quelled, 21 executed in a gruesome fashion. In 1739, a group of enslaved Africans, some with military training, led by a man named Jemmy or Cato, sparked a revolt near Charleston, South Carolina, near the Stono River. They raised a standard and, with cries of liberty, seized weapons, cut down opposition, eventually settled down at a riverbank for reinforcements. Instead, they were confronted and suppressed by the white militia, armed, I might add, with their own private weapons. In 1800, a blacksmith named Gabriel, steeped in an atmosphere of talk of liberty and natural rights, planned a multiracial Republican revolution in Henrico County, Virginia. The plan involved enlisting slaves with access to firearms and swords, a march to Richmond to obtain more weapons, and the hoisting of a banner with the words "Death or Liberty" emblazoned upon it. However, this plan too was betrayed and the incipient revolution quashed. 20 years later, a free black polyglot named Denmark Vesey led an abortive revolution in Charleston County, South Carolina. He was armed with a copy of Rufus King's natural law denunciation of slavery, and he was surrounded by reports of a successful slave revolution in Saint-Domingue, which is now Haiti, and drew up a plan of attack. Before this plan could commence, he and his comrades were betrayed, captured, and executed. A decade later, Nat Turner commenced an uprising in Southampton, Virginia that took place on August 21st, 1831, but was initially planned for July the 4th. It was a shockingly bloody business, but one that Turner exhorted was, quote, not a war for robbery, nor to satisfy our passions, but a struggle for freedom. Nat Turner's rebellion, like those before, ended with capture, executions, and mass punishment for the black population. The hypocrisy of American revolutionary rhetoric was not lost on these men and women who ventured their lives for liberty. In the American Museum magazine, a piece by, quote, a free Negro asked, quote, do the rights of nature cease to be such when a Negro is enjoying them? Or does patriotism in the heart of the African rankle into treason? A black man hanged for his part in Gabriel's rebellion said this, quote, I have nothing more to offer than what George Washington would have had to offer had he been taken by the British and put to trial by them. I have adventured my life in endeavoring to obtain liberty for my countrymen. And although African Americans and their allies expressly appealed to principles of natural right to justify political violence, although they seized weapons to effectuate their plans, their revolutions were almost always viewed as acts of riot and menace and not as justified acts of liberation. And the response by authorities was frequently to impose ever more punitive and draconian sanctions. The same generation of Americans that acted on John Locke's theories of morally justified political violence and who armed themselves to defy British laws they described as, quote, intolerable, imposed a brutal, hereditary, and thoroughly racialized form of slavery in the United States. In South Carolina in 1690, an act for the better ordering of slaves enacted just after publication of John Locke's two treatises of government immunized private individuals who killed a slave resisting arrest for trying to flee servitude. 10 years later, they updated the law to require the imposition of ear cropping, branding, hobbling, and castration upon those who sought to free themselves. Many of these repressive slave codes trafficked in the same usurpations that the founding fathers denounced as justification for a war of independence. Slaves were denied basic liberties guaranteed under the common law. They were subjected to alien laws, like partus sequitur ventrum, rather than the common law custom that the status of the child would follow the father rather than the mother. Slaves were subject to punishment by specific tribunals if any process was available at all. They were denied an ability to assemble, to engage in a trade, to speak, to sell labor, to own property or arms. All these were subject to restriction or prohibition. Every article that's lodged against George III in his Declaration of Independence of Thomas Jefferson was intensified in the laws that regulated Africans in America during this time. But this perversion of the American tradition of violent resistance to despotism did not end with the Revolutionary War. Throughout American history, enslavers, white supremacists, and their apologists have used the rhetorical power of subjugation and resistance to tyranny to justify their own acts of armed oppression. As far back as the founding era, some slave owners characterized limits on their ability to own property and human beings as a violation of natural liberty. Slavery's apologists argued that natural law itself supported African enslavement. Jefferson Davis, upon assuming the presidency of the Confederacy and the commencement of the Civil War, announced that the slaveholders' governments had, quote, merely asserted the right, which the Declaration of Independence of July 4th, 1776, defined to be inalienable. After the Civil War ended at Appomattox, white supremacist organizations like the Klan invoked the spirit of the Revolutionary War and inalienable rights to self-defense as the basis and justification for their campaign of terror against freedmen and their allies. A century later, on July 4th, 1964, the arch segregationist George Wallace denounced the Civil Rights Act of 1964 as, quote, a fraud, a sham, a hoax, with repeated invocations and quotations from the Declaration. Now, the most recent version of this corruption occurred on January 6, 2021. Hundreds of supporters of then President Donald J. Trump, some armed, whipped into a frenzy by false claims of voter fraud and a stolen election, stormed the seat of the national government, beating police, threatening lawmakers, calling for the hanging of the Vice President of the United States. They attacked the seat of government with Gadsden flags. They paraded a Confederate battle flag through the Capitol. Now, right-wing media still refuse to condemn these rioters, and some current politicos have referred to them as patriots. Two Republican Congress members even called January 6th the, quote, Republican 1776 moment. But I think the prize for candor goes to Ron Johnson, a sitting Republican senator from Wisconsin. Johnson, who literally had to take refuge from the mob on January 6th, had this to say about the insurrectionists. This is the quote. Even though those thousands of people that were marching to the Capitol were trying to pressure people like me to vote the way they wanted me to vote, I knew those were people that love this country, that truly respect law enforcement, would never do anything to break the law, so I wasn't concerned. Now, had the tables been turned and President Trump won the election and those were tens of thousands of Black Lives Matter and Antifa protesters, I might have been a little concerned. Now, the implication of the senator's statement is clear, and it's this. For these insurrectionists, the only legitimate political violence is white political violence, because only whites can legitimately use violence to overthrow a white man's government. Now, let me turn to the nonviolent tradition. Seizing by force those rights that won't be willingly surrendered is only one tradition in American history. There's also another tradition whose heroes are rarely stamped onto coins, rarely have equestrian statues raised in their honor, but whose torn and broken bodies really bear up modern America. Enslaved persons, denied effective use of violence for universal liberation, engaged in numerous acts of small, quiet rebellion, breaking tools, feigning sickness or deafness. More than 100,000 of them engaged in self emancipation at great personal risk and certainly risk to their families. Abolitionists and their allies resisted slavery and discrimination also through nonviolence. In 1847, Francis Wayland, the president of Brown University, encouraged passive resistance to combat slavery. Widespread noncompliance with the reviled fugitive slave law of 1850 rendered its enforcement costly and difficult in the North. During what's often called the long civil rights movement that begins roughly after Reconstruction, two features are apparent: a commitment to nonviolent political change and a commitment to full equality as American citizens. These are not separatist movements. They are not struggles for a separate Black homeland. They are struggles by Black Americans to the birthrights of all Americans as Americans. 90 years before Rosa Parks sparked the Montgomery bus boycott, Octavius Catto refused to sit in a segregated rail car in Philadelphia and joined his fellow citizens to do the same. The priest and lawyer Parley Murray outlined a multi-pronged strategy of nonviolent resistance to segregation in the fall of 1942. And that same year, A. Philip Randolph, with his March on Washington movement, endorsed a set of principles of nonviolent resistance based on the model of Gandhi in India, including boycotts, civil disobedience, and subjection, but not resignation to arrest. The long civil rights movement culminates in the period in the early 1950s and 60s and features coordinated, widespread, and persistent nonviolent confrontation as the primary political program of African Americans and their allies. Young men and women during these sit-in protests are trained how to sit still while hot coffee is poured in their laps, how to resist the urge to throw a punch when every instinct of self-preservation and self-defense would tell them to lash out with fists or weapons. African Americans had every moral right to develop a military capacity to engage in a violent guerrilla campaign to force political compromise, but civil rights leaders chose nonviolent passive resistance to segregation and disenfranchisement through the freedom rides, through sit-ins, through the Freedom Summer, even at the cost of their very lives. Martin Luther King Jr. became the political leader of this nonviolent army as he spoke shortly after taking leadership of the bus boycott. Quote, "First and foremost, we are American citizens, and we are determined to apply our citizenship to the fullness of its means. This was to be a revolution through peaceful resistance." He said, quote, "We are not here advocating violence. No whites would be pulled from their beds and murdered in the street. That was the work of the Klan. Quote, "The only weapon that we have is in our hands," he said, "is the weapon of protest." And on March 7th, 1965, a bloody Sunday, a march across Edmund Pettus Bridge in support of voting rights cemented the historical meaning of this strategy. Civil rights workers in the years before had been very scrupulous about removing any visible threat of violence in their political campaigns for the previous months. So, even going so far as to tell marchers to surrender rulers or pens or pencils or anything that could be mistaken for a weapon. And this march was no different. John Lewis led approximately 500 unarmed supporters to the bridge. The Alabama state troopers gave them 2 minutes to disperse, and when they held fast, ordered their troops to advance with tear gas and batons. ABC interrupted a broadcast of the judgment at Nuremberg to televise the attack. Viewers who just moments before had been watching scenes of Nazi atrocity and European complicity were suddenly confronted with images of Alabama troopers clubbing peaceful civil rights workers right here in America. It was a political watershed, and a week later, President Lyndon Johnson introduced the Voting Rights Act of 1965 in his address to Congress. His speech captured the historical moment. He said, quote, "At times, history and fate meet in a single time in a single place to shape a turning point in man's unending search for freedom. So it was at Lexington and Concord. So it was a century ago at Appomattox. So it was last week in Selma, Alabama." So I want to end my remarks by returning to the Declaration. The Declaration of Independence, no doubt, is a political document, but it's also a kind of legal one. The litany of abuses in the Declaration of Independence read as a bill of particulars against a tyrannical monarch. It's even fashioned as a bill of equity, according to the fashion of the time in some ways. The court rendering judgment in this case is not a sovereign tribunal, but is one of international and intergenerational opinion. The founders must explain themselves, and they do, but Jefferson's appeal is wanting. Frederick Douglass recognized the founders' shortfalls in his 1852 speech, quote, "What to the American slave is your 4th of July?" And he said, quote, "I answer a day that reveals to him more than all the other days in the year the gross injustice and cruelty to which he is the constant victim." In the language of the law, equity will not rescue the wrongdoer. One must seek equity, as they say, with clean hands, and it's hard to imagine hands more begrimed than those of the founding fathers. At the time the Constitution is drafted, 700,000, or roughly 1 in 6 of the American population, is enslaved. By 1860, property in human beings equals half the nation's GDP. After Reconstruction, terrorists operate to suppress Black political power through officially acquiesced violence. Penal systems are turned into slave labor tools, and in the ensuing decades, in ways profound and petty, African Americans are subjected to a train abuses. African Americans have had over 400 years of justification to use violence as an organizing principle for political change. The balance of the equities at the turn of the 20th century clearly favored force against oppression, but instead of a guerrilla campaign against oppressors, instead of assassinating segregationists and besieging the seats of white supremacy, African Americans turned the other cheek, not in resignation, but in defiance. This requires a reckoning for anyone who claims from first principles to resort to political violence. The group with the most warrant to use it didn't. The Declaration of Independence in American political life functions as what Richard Primes has called a continuity tender, which he says is, quote, "an inherited ritual formula that one repeats to affirm a connection to one's predecessors." Every appeal to fundamental constitutional change in America performs this ritual of tracing its origin to the Declaration. However, the civil rights movement and its commitment peaceful revolutionary change rather than violent insurrection provides a fundamentally different baseline morally than the founders or anyone invoking this tender. The figures of Martin Luther King and the patriots for nonviolent constitutional change exposed the moral bankruptcy, obviously, of violent segregationists in the 1960s, but I think they simultaneously exposed the moral bankruptcy of the claims to justified violence by Thomas Jefferson and George Washington. Their bravery discredits the January 6th insurrectionists who claim they had no other choice. Their struggle shames pundits who claim that political violence is a fundamental, essential to the American constitutional character. And their sacrifice, I think, acts as a warning for all those who would tear down the true monuments of America's commitment to nonviolent constitutional change, the Civil Rights Act of 1964 and the Voting Rights Act of 1965. The metric for justifying political violence in America is the African American experience. African Americans have had 4 centuries of reason to give up on the American experiment. Instead, as President Barack Obama said, African Americans and their allies have fought to, quote, "bring those words in our founding documents to life. And so long as we continue to honor that choice of our ancestors to protect what they suffered for and to forswear violence in favor of nonviolent confrontation and peaceful political solutions, then I believe that grace will continue to expose the lie of any lesser claim. Thank you very much for the opportunity to speak on this important topic.
Well, thank you, Professor Miller, for that robust and rich analysis of historical civil rights and civil disobedience movements, and how that contrasts with our very current and very real experiences of political violence today as a means of achieving change. But with this stage set between the interactions of the First and Second Amendments and this historical look at what political change can and perhaps should look like, we'll then turn to Professors Reva Siegel and Professor Joseph Blocher presenting jointly with a more contemporary look through the lens of the Second Amendment. Joseph Riegel.
Okay, so I want to start off by thanking the organizers for this symposium and our moderator, and thanking our panelists, Greg, and thanking Daryl for a riveting presentation of what is a brilliant paper. I want to commend it to everyone in the audience as a very important rereading of American traditions of the founding and really its relationship to constitutional change. And say that this is really an important convening, and I'm going to try to situate Joseph's and my writings. We're co-presenting this afternoon. So Joseph and I have been writing now on the relationship between guns, democracy, and race inequality for the past few years. And in our joint remarks today, we're going to be talking a bit about the relationship between guns, democracy, and equality, and showing how the court's recent Second Amendment jurisprudence is a threat to democracy and to race equality. We'll begin by distinguishing two different accounts of gun violence. One model focuses on the physical harms of gun violence. The physical harms model initially seems reasonable in foregrounding the ability of guns to inflict bodily injury. But this physical model then quietly ignores the impact of gun violence on social relationships. By contrast, the social harms model of gun violence focuses on how the very capacity of weapons to threaten bodily injury and death distributes power and authority, both practically and symbolically, between individuals and groups in society, including along the axes of race and gender. The court's Second Amendment jurisprudence is very much rooted in the physical harms model. The physical harms model of gun violence centers the story of armed self-defense that the courts offered as the raison d'etre of the Second Amendment case law ever since District of Columbia versus Heller in 2008, and again in the recent Bruen decision extending the right of armed self-defense to public settings. These decisions elevate the individual right of self-defense without recognizing how bearers of weapons enforce viewpoints or social status. These Second Amendment decisions offer thin, impoverished accounts of public safety, and because they do, we've argued across a series of papers, they erode the public sphere on which constitutional democracy itself depends. So in today's remarks, we're going to begin by distinguishing between these two models of gun violence. And for reasons of brevity, these remarks can only suggest how this physical model is judicialized and employed by courts in offering impoverished accounts of public safety to justify striking down laws that regulate guns. The result, we suggest, entrenches racialized and gendered power. And in closing our remarks today, we're going to join those who caution that over-reliance on criminal law methods to achieve public safety or gun safety can also impose harms on communities of color. So we'll close by suggesting some solutions to pursue public safety, which, though imperfect, can be pursued in democratic politics as substitutes and complements to the criminal law. and we'll leave this to be discussed a bit in Q&A if people are interested. Our main point in these remarks, which are summary of several of our papers, is to encourage thinking about weapons in an interdisciplinary model that embeds violence in social relationships, including histories of status inequality. It's the basis for our work on the Second Amendment, both the right side and of their public safety regulation. So I'm going to start in my section of the remarks to describe and exemplify these two different models of harm, physical and social. So the reason that we regulate guns or fight over regulating guns starts with the immense harms that they can inflict. But now we need to think a bit about the nature of that harm. Every account begins in the obscene tally of injury and death, focusing on CDC statistics. Yet starting to count that way measures the harm of guns by the physical harms they inflict. And our object in exploring the social harms model, which can be elaborated from a variety of disciplinary perspectives, is to make visible the threats guns pose to democracy and to the forms of equal citizenship on which democracies depend. What do we mean by the social harms model? As we look beyond the number of Americans wounded and killed by guns and begin to take account of the uncounted number of people traumatized by these shootings, we can see even the threat of gun violence can inflict injuries without inflicting physical wounds. The case of trauma should cue us to this broader social field. Both the experience and the threat of gun violence can shape the ways people live together. The use of guns, the memory of guns, the fear of guns, the threat of guns, all shape social relationships. So to illustrate, consider three linked examples. Many efforts to count school shootings victims tally the students killed, more than 300 since Columbine. But that number grows if we add to that tally the students harmed by the threat of violence. How do we count? First, the circle we can look to is the survivors of school shootings. More than 300,000 students have experienced gun violence at school since Columbine. Many have psychological difficulties and perform worse in school. But what of those who have a reason to fear school shooting? Parents are now vigilant in safeguarding their children against this dread prospect. Active shooter drills are conducted for virtually all of the 500 million students enrolled in K through schools today. A recent study shows that in the months before and after drills, 40% of students experience an increase in depression and anxiety. Measures of anxiety aside, active shooter drills ensure that all students experience imminent shooting as a feature of their everyday school life. Watch how that ring expands. Now consider the case of intimate partner violence, which, like today's focus on white supremacy, involves a fundamental threat to equal status. When Congress adopted the Lautenberg Amendment in 1996, which prohibits gun possession by persons convicted of misdemeanor domestic violence, Congress focused on the prevention of physical harms. And for understandable reasons, roughly half female murder victims in the United States are killed by intimate partners, more than half by gun. These are clear physical harms, and law can help prevent them. But there's a broader problem here as well. Most abusers use guns as instruments for intimidating and coercing their victims, and not only physically harming them. Once we recognize the threat dynamic in domestic violence, we can better understand how guns shape the public sphere more generally. So now we move to our third example. Consider the role that gun display increasingly plays in public life, even when guns are not fired and arguably not even brandished within the legal meaning of the term. 15 years ago, the open carry of firearms at public protests would have been a shocking sight, but it is now increasingly commonplace. The practice of open carry, often by Americans in military garb, and frequently in masses, is now a familiar feature of demonstrations, asymmetrically and strongly associated with conservative protest. We often see arms openly displayed at protests, whether the counter protest is in response to claims for gun control, to claims for racial justice, to COVID shutdown orders, or to ballot counts or recounts. Consider the growing number of incidents at which armed protesters or the threat of armed invasions have forced the closure of democratic institutions, from the Michigan legislature in the spring of 2020 in the US to the US Capitol in the spring of 2021. That law enforcement allowed masses of overwhelmingly white and male protesters armed with rifles to threaten the governor and shut down the legislature with impunity did not pass unremarked. U.S. Representative Rashida Tlaib, put the distinction in clear terms. Black people get executed by police for just existing, while people dressed like militia members carrying assault weapons are allowed to threaten state legislators and staff. Why bring and openly display weapons? In certain cases, protesters are bringing guns as vigilantes in the expectation they will need to act to protect life and property as substitutes for the state. Think of young Kyle Rittenhouse. Even more often, protesters bring along arms as part of a political dispute, to express political identity, to stand their political ground, as it were, and to assert their will to govern. Why else would arms be displayed at protests not involving the regulation of guns, involving the shutdown orders or vaccine mandates or ballot audits? And how do unarmed citizens respond to all of this?
So to illustrate how the activities Riva has just described can threaten democracy and equality and therefore give space to white supremacy, consider the growing number of people who may be deterred from fully exercising their constitutional rights because they feel threatened by armed individuals or paramilitary-style groups. This is not an irrational fear, as Diana Palmer and Tim Zick found in 2022, that 1 in 6 armed protests turn violent, sometimes including gun violence. So as we're increasingly coming to appreciate, guns can threaten the exercise of other constitutional freedoms. And for that very reason, gun regulation can provide Americans with the security to move freely in the public sphere so that they can speak, assemble, legislate, vote, learn, and worship without fear. And when the state regulates guns to protect public safety, it does so simultaneously to protect the physical person and the broader body politic, providing the physical security necessary for the exercise of all of our constitutional liberties, including the social harms which Riva has described in the constitutional calculus, transforms it. Because we no longer find ourselves balancing or accommodating, on the one hand, the right to keep and bear arms against the government's interest in promoting physical safety. Instead, when we recognize the social dimension of gun use, we can more easily see the constitutional freedoms being asserted on all sides of the gun debate. Now, for more than 200 years of American history, the regulation of weapons to prevent these physical and social harms was primarily a matter for politics and not for the courts. It was not until 2008 in District of Columbia versus Heller that the Supreme Court claimed for itself and for federal courts a larger role in policing the regulation of guns. And it wasn't until this past summer, as Tim described in his opening remarks, that the court in Bruen claimed even more space. That intrusion into the process has deep implications for democracy and equality, and therefore for how we understand white supremacy. While many conservatives celebrated the 2008 decision in Heller as the finest example of what is now called original public meaning jurisprudence ever adopted by the Supreme Court, other conservatives warned that the decision invited Americans to do what conservative jurists warned for years they should not do, which is bypass the ballot and seek to press their political agenda in the courts. Now, we do not equate democracy with majority will. Those two things are not identical. But it is notable that the Supreme Court is emphasizing gun rights in ways that seem to conflict with the expressed preferences of the American people, and particularly of communities of color, which are most ravaged by gun violence. A recent Pew poll found that about 8 in 10, 82% of Black adults say that gun violence is a very big problem, which is by far the largest share of any racial or ethnic group. More than double, in fact, the 39% of white adults who say so. A separate Pew poll found that majorities of Black adults, 75%, Asian adults, 72%, and Hispanic adults, 65%, say that gun laws should be stricter compared to just 45% of white adults. Now, these expressions of support for further gun regulation can be understood as a form of self-defense through law rather than through guns, and they track the distribution of physical harms that you've already heard described. Black Americans, according to some studies, are 10 times more likely than white Americans to die from gun violence. They comprise about 13% of the population and about 59% of gun violence homicide victims. Young Black men are about 14 times more likely to die of firearm homicide than white men. And young Black teenagers and men, that is ages 15 to 34, make up 37% of the nation's gun homicides, despite comprising just 2% of the population. And although it is harder to measure, an expanded right to keep and bear arms can also exacerbate inequality of the social kind that Riva described. Because weapons threats, and the enforcement of weapons laws have long played a role in enforcing status inequalities along the lines of gender and race. Perhaps today, a Black man can arm himself for self-defense, but if he does, will he be treated like the overwhelmingly white armed protesters who invaded the Michigan Capitol, not one of whom was arrested for doing so? Think again of the quote from Senator Johnson that Daryl read. Of course, none of this means that communities of color, nor anyone else, should be comfortable with the countervailing costs of enforcing gun laws. Lawyers and others writing with concern for the over-reliance on criminal law have increasingly emphasized, and rightly so, the degree to which gun laws can exacerbate the harms inflicted by imprisonment and state-inflicted violence, which are also disproportionately borne by communities of color. These are real harms, and it's crucial that advocates for gun violence prevention recognize them. The question then becomes how gun regulation, a form of community self-defense, can minimize the physical and social harms of guns without worsening other forms of status inequality or inflicting other forms of violence. Does the solution lie in judicial expansion of the Second Amendment or in political action through elected officials? We argue that the best, not ideal, but best path forward still lies in democratic politics. Now, in saying this, we do not leave the Constitution behind. To the contrary, all government actors, and not only judges, should enforce the Constitution. And actors in representative government can do so with institutional resources that judges lack. That means that democratic actors can do what federal courts won't, and they can do much more than federal courts can to advance equality in the course of promoting public safety. Notably, some of these developments are already visible in shifting policy and political priorities. At the national, state, and local level, advocates have sought to de-emphasize prosecution for gun possession crimes and to allocate more resources for background checks or for community violence intervention programs, which have been shown to break cycles of violence by connecting high-risk individuals to wraparound social services, including counseling, education, and employment opportunities. Those programs are now a centerpiece of the Biden administration's gun violence prevention plan. In some cities at the local level, progressive prosecutors have campaigned on proposals for combating gun violence that lead with non-carceral interventions and follow with measured gun control legislation and enforcement policies. And there is an accumulating body of evidence that reducing prosecution and incarceration for certain gun offenses is efficient as well as equitable. And cities are weighing how these new constitutionally informed approaches to public safety might be implemented. Now, of course, as with any approach to reform, there has been opposition, including from law enforcement. Our point is not that a perfect equilibrium has been reached, but that government officials are now seeking to coordinate non-discriminatory law enforcement and transformed, less carceral approaches to public safety and debating the proper balance between them. Whatever the deficiencies of those reform efforts thus far, the Supreme Court's expansion of Second Amendment rights is unlikely to improve them. It has been decades since the Supreme Court has demonstrated leadership in the pursuit of racial justice. The current court is ready to denounce racism of the past, but when it comes to the forms of inequality currently afflicting minority communities, the court too often interprets the Constitution to license that inequality and to obstruct efforts to dismantle it. Modern communities need a wide range of resources to combat gun violence, and critically, they need the democratic authority to experiment and deliberate about how best to preserve the public safety of all their members when both human life and the shape of constitutional community are at stake. The question of how to deliver public safety equitably and effectively is likely to vary across communities and over time, and especially at the present, it is more likely to be achieved through democratic politics than in the federal courts.
Thank you so much for the insightful presentation, Riva and Joseph. And with all of these insights gathered of historical interpretations of rights and laws, of histories of movements towards justice and the different means used to attain them, and a more contemporary look at the different ways that these laws and these rights and how we view them through the courts and our legislative systems impacts the lives and experiences of people across the nation, can now to try and fuse all these ideas into a question and answer session where you get to explore a little more depth. So the first question, anyone can feel free to take it, and you all have robust expertise to add. The more looks at in the legislative sphere when we hear people talking about the Second Amendment, and even more so in judicial opinions being released, we see this notion of the Second Amendment being referred to as a second-class right and being treated in a way that's inconsistent with other constitutional rights. I wanted to open this up to the panel to see what your thoughts are on that notion of, is the Second Amendment truly an exceptional right in a way that's treated differently than other rights? And if so, what is the best way to approach that notion?
Well, I can take an initial crack at this. I think the fallacy of the argument that the Second Amendment is treated as a second-class right is that whatever one thinks of the Second Amendment and the individual right to keep and bear arms, it's distinct from any other kind of right that we have recognized. The baseline that people who make this argument most often invoke is the First Amendment. Look how rigorously and robustly we enforce the First Amendment compared to ways in which the Second Amendment has been treated as a lesser right. Well, First and Second Amendment rights are very different things. They protect very different kinds of activities. And there's no sort of logical reason that we would think they would be treated in comparable ways. The Second Amendment is in its own way sui generis. Now, the Supreme Court in the Bruen decision, I think, has sort of embraced this idea that the Second Amendment must be treated the same as other rights and must be enforced in an equally rigorous way. But even by the standards of Bruen, what that means for the Second Amendment doesn't really bear any relationship or any resemblance to what robust enforcement means for First Amendment rights or criminal procedure rights or anything else in the Constitution. So I think we have to recognize that we're looking at different phenomena, and we have to evaluate each different sort of constitutional right on its own terms.
I want to say something and then turn this over to Joseph, who is the authority on this claim. Who's written widely on this claim, and it can say some empirical things about this claim. First, I'd like to observe for people in the audience that it is by no means clear. Well, it is for those of you in the audience who are interested, the court has claimed that its current jurisprudence is the outworking of the original understanding of the Second Amendment. That is at least a contestable claim. It claims that the right to armed self-defense is an original understanding that's in the text of the Second Amendment. I invite the audience to reread the text of the Second Amendment and see if you can find the word self-defense in the text of the Second Amendment. The words don't appear there. It's at least worthy of inquiry. We don't have time in this panel to discuss it, but the status of the Heller decision and its historical grounding was the subject of a wide-ranging discussion, and there's a body of scholarship even on the Heller reading. All of that is water under the bridge because the court is now populated by justices who are the justices in the majority have the authority to enforce it. My second point is a claim about second-class right is not an originalist reading of the Second Amendment. So with that, I will now turn it over to Joseph, who's made inquiry into claims about the claim second-class right. Go for it, Joseph.
And I'll keep it quick because I'll end up echoing a lot of what Greg and Riva just said. But just to elaborate 3 points, and here and just to nod to work that I've done with Eric Rubin of the SMU Law School and an article in the Georgetown Law Review on Georgetown Law Journal rather on exactly this question, and in an op-ed in the Washington Post. 3 things that stand out to me from the claim. One, consistent with the theme of this gathering, albeit in a very twisted way, the Second Amendment, the Second Amendment is a second-class right argument, is often paired with language borrowed from the aftermath of Brown versus Board of Education. So the claim is made and the allegation is made that lower federal courts are engaged in massive resistance to the Supreme Court's decision in Heller. Now, that phrase massive resistance, of course, is a callback to the resistance to desegregation in the aftermath of Brown versus Board of Education. It is an incredible flip of the script about who is being portrayed as sort of victim of an anti-constitutional movement. The other thing I would note is that many of those who make this claim also separately are making the claim that actually the Second Amendment is primary. The literal name of one of the NRA's magazines is America's First Freedom. This is not an argument for equality of rights. It's an argument for primacy of rights with the guns on the top. And Daryl has written about this and others, that what the Second Amendment has received, especially after Bruen, is a kind of supercharged protection that other rights, including the freedom of speech in many contexts, don't have. And then the third thing I'll just note, there's a lot to be said from the articles that Eric and I have worked on. We try to trace how this argument has traveled from briefs to judges and to justices. But one thing to note is that it is overwhelmingly embraced by judges and justices appointed by Republican presidents. This is not an argument that has had appeal across party of appointing president. At least it seems to resonate with judges who have at least a certain kind of affiliation of their nominating president.
Well, thank you all for that address of the question. And Daryl, I have a question for you. Looking again to uses in judicial rhetoric, especially in the briefing leading up to the Nazirba v. Bruen opinion, and also some of the questions and stances for some of the justices about how expanding gun rights and ownership is something that will help communities of color as opposed to harm them, and it's a way of righting past injustices. I wonder what your perspective is on that line of rhetoric when looking at the contention of deciding whether to expand or reduce gun access and use as a matter of civil rights.
Right. It's a really excellent question, one I've been thinking a lot on. And I think there's two real vulnerabilities to that set of arguments. One is the sort of history proving too much. So if you scratch almost any regulation in American history, you're going to find some kind of inequitable or racist, either reason or intent or implementation of it. The very black codes that are often cited that were very much about prohibiting African Americans from owning guns also are sit side by side regulations on certain types of practices or professions. So the reason why I say it proves too much is you kind of have to look at the regulation, the present version of the regulation, on its own merits. The fact that the licensing of attorneys or of physicians or of plumbers was sometimes used as a cover for racist inequitable practices is not a reason alone to say, ergo, it must be unconstitutional to license plumbers or lawyers or physicians. The second problem with it is what I would say is the too great a focus on the disparate impacts, the present disparate impact of regulations. So the arguments by the Black public defenders, the Bronx defenders in Bruen, focused quite rightly on the effect that criminal justice has in the gun area on communities of color. But as the NAACP it's, also said, and as Joseph and Riva have pointed out, gun violence is also not equally distributed in society. So the problem isn't, you have disparate impacts in this one margin, and therefore you address that without addressing the 360-degree problem, which is that doing nothing also leads to inequities and violence. And so the problem needs to be viewed in its totality as opposed to along one margin.
Well, thanks, Daryl. Nuanced answer to a nuanced question. So we received another question from the chat. This one is more of, there's a little prelude with the question after it, so I'll just read what they asked. They state that I think that many of the court decisions on Bruen, e.g. domestic violence, referring to the recent Fifth Circuit opinion, misread the opinion. The concurring opinions of Bruen suggest an understanding of the majority opinion that suggests if a court decision goes too far, at least 3 of the justices cannot necessarily be counted on for another majority, which I suppose they're essentially saying if an opinion from a lower court seems too extreme, for instance, the striking down of 922 G8, the domestic violence protection order prohibition for gun possession that surprised many legal scholars and members of the public alike, then it wouldn't have a sufficient majority to uphold it. So I suppose this questioner is wondering what your all thoughts are on that perspective, especially in light of more and more surprising opinions coming out with the relative ambiguity and looseness of the application of Bruen's history test.
So let me try to take a quick stab at this question, just because I think it's a good point and one that's not appearing as much in the opinions yet as one would think, which is you have this unusual scenario where you have 3 members that form the 6 justice majority in Bruen writing concurrences that read as if they are simply concurring in the judgment or are trying to sort of trim the sails of a majority opinion in which they also joined. So Justice Alito says, we are just deciding a matter of public carry restrictions. We're not addressing any other question. Justice Kavanaugh, joined by the chief, write an opinion in which they essentially say, properly understood, the Second Amendment allows a wide range of gun regulations and includes the language that was quite familiar between Heller and Bruen, that nothing in the opinion should be taken to cast down on longstanding prohibitions on firearms in the hands of felons or the mentally ill, guns in sensitive places. So what I think is happening, or at least is a potential future trajectory, is one of 2 things. Either lower courts engaging this are going to have to synthesize and harmonize the language from the majority opinion with the concurrences, or depending on when the Supreme Court hears a new case, and I think it's likely that they'll have to hear one sooner rather than later, especially if lower courts keep striking down major federal pieces of legislation, this will be the opportunity for the concurrences of Justice Alito and Justice Kavanaugh to explain what they meant by what exactly is still on the table in terms of constitutional regulation after Bruen.
Can I say something here? I think that I was actually just talking to a student about this today. I think this is a case where there's been an unfortunate convergence of the left and the right here. As one who has written critically of what the court is doing in other areas, there's a strong instinct to come flying at the court and just trash the court for this opinion. But the net effect of that is to produce a commentariat where the libertarians and gun rights and originalists are going to want to read Bruen as too generous and argued for a narrowing reading of Bruen. And then the critics are going to say the sky is falling. It's too messy, and it's going to cut back too much law. And creates this it creates a storyline in the sort of aftermath of the decision about the opinion as being what Thomas said or worse, and as opposed to what you're saying, Daryl. And what's needed out there is somebody to hold their nose and point the way to a more reasonable set of outcomes, even though the court deserves wide-ranging critique for what it's done. And so right now, there are laws being struck down where there's space in the decision and potentially space on this court to come to a different result. Roberts was the one who was the problematic vote before the composition of the court moved to the right. So there may be, I'm not predicting, like I'm not holding myself out as the great knowing person about this bench, but there may be, as you're suggesting, Daryl, a court that's willing to narrow this decision if its hand gets forced, if it does take a case. It may not be rushing to, but it may narrow this or put complicating language in that can be used to narrow it, even though there are lower court judges who have a desire to move to the right of Bruen, So I do think, even for those who are critical of the court, that there's a reason to speak in ways that provide rational routes to to showing how Bruen makes a frame can be read, to provide readings of Bruen that create frameworks for gun regulation more than the courts that have spoken the loudest.
And I know we're short on time, Tim, but if I could take 30 seconds to demonstrate the nose holding approach that Riva was just describing, something she and I are trying to do in our current scholarship, is that these domestic violence restraining order cases, of which there are now a few, including the Fifth Circuit case, I think are reading the Bruen decision as if it does not license any forms of change. Daryl gave an explanation of why that might not be true given the concurring opinion. I would just say that Riva and I in our current work are trying to show how that's true even under Justice Thomas's majority opinion, which actually does license various forms of change. It extends nominally, at least, protection to new forms of arms. It upholds shall issue licensing, which did not exist in its current form, at least in 1791 when the Second Amendment was ratified. And if those things are both true, then it may also be true that the court would be open to recognizing changes in status equality, whether they are tied to race, like with white supremacy and the theme of this panel or of this day, or as is in the case of gender, changing norms and equality about whose lives are worth protecting through law, about which Riva has written an entire fantastic article everybody should read called The Rule of Love. I'll stop there.
Mostly the court it recognizes change in equality of membership in the service of recognizing gun rights, but we should call them on it and insist that the same capacity to recognize change should extend also to gun regulation, like the law at issue in Rahimi and Perez Gallon, the DV prohibitor cases.
Well, thank you all so much for all of your time and insights this afternoon. You're certainly invaluable and help increase the scope of the way in which we can view the complexities of the Second Amendment and the history of politics and political change in our country, and then how we can use all of those past lessons learned, perspectives gained, to inform this very uncertain future we see ourselves in with actions on the courts and different state legislatures on issues pertaining to firearm rights and other civil liberties. So let's look back at a few things we can take away from that notion. We've seen that there is far from a compatibility between the First and Second Amendment, as many espouse it to be an element of speech or facilitator of speech. There's very valid considerations that the act of firearm carrying itself can be contrary to the First Amendment and counteract the exhibition of several other civil rights and liberties that we see as the core foundations of our democracy. We've looked at the history of political violence and political nonviolence as means of change, especially through the lens of civil rights and the movements of freedom for Black Americans, and have seen that far from this insurrectionary theory that may have been mentioned earlier today, which views the Second Amendment as a means to violently overthrow tyrannical government, we've seen that those who are arguably in the best position of all to seek violence as a means of change have instead chosen peace and protest as options, and have, in doing so, meaningfully changed the course of our country. And then we've also looked at more contemporary looks at how the Second Amendment and its current expanded state interfaces with other rights, and how our view of the harms reaped by gun violence, whether they're purely physical or social, can help change the debate of how we look at the permissible regulation of firearms. Also, meaningful steps forward that we can take both at the judicial level, but also largely at the legislative level, in instigating change that can help protect and enshrine civil rights and liberties while promoting peace and public understanding and safety in ways that can quell rising risks and concerns of ideologically motivated violence along the lines of those employed by white supremacists. So I want to thank all of our panelists, and for those of you who came to learn with us today.
Thank you, Tim, and to our panelists. Certainly, today has been a day of being in a space and being in community with all of you that has been quite emotional, quite revealing, if I could say exhausting in many ways, emotionally charged, and triggering in many spaces. And there's so much that I want us to take a moment to reflect on and hear each of your thoughts in terms of what you are sitting with and what the day has been like for you. I know during many of the breaks, we shared our own stories, we shared our own thoughts and our own feelings. You know, we started out today hearing from the Reverend Sharon Risher and her personal stories and her reflections and the opportunities that of how to move forward as a survivor and what it means to be a survivor. And Janelle, thank you so much for your leadership in that interview and really helping us to see the space and Sharon more than as just a survivor, but as a grandma, as an individual, as a chaplain, and all of the weight that she's carrying in that space and the humanity of what this space holds. You know, we heard about the history of political violence. We talked about race, democracy, and white supremacy. We certainly know the importance of data and what we need to do when we see data and how we use the data to inform different actions and our approaches to policy and our approaches to advocacy. And so today has been filled with many opportunities for us to think about in ways that we should move forward. I do want to say I would be remiss if I don't mention the Bloomberg American Health Initiative, and certainly we are focused on making impacts across 5 very specific areas, one of those areas being violence. And Janelle, you are an alum of our fellowship program, and certainly thinking about and looking about all of the various aspects of violence, including domestic violence, including urban violence, community violence, white supremacy, and the violence that comes along with that. And so I'm going to pause there because I really want to hear your reflections. And I think the question is, what are you sitting with? And I will ask you first, Janelle, given all that we've heard today, what are you sitting with?
Thanks, Michelle. A few things. It has been a very emotional day. It's been taxing. And as much as we have the urge to distance ourselves from that, I think we shouldn't. Because when we distance ourselves from certain emotions, I think that is a pathway that allows these types of ideologies to creep in and to propagate and to inflict the harm that they are able to. So I think we need to hold on to what it is that we're feeling, really lean into it and notice it. I like to think of anger, especially when we're talking about instances of oppression and injustice, as an indication something is off here, something's not right. I deserve better. We all deserve better. I like to think of anger as an embodied justice, because it can motivate us to make change that improves things for everyone. I'm also thinking about reflecting on Ray's research and the qualitative focus groups that they conducted, and just thinking about the quotes from some of the participants of that research, and how when I saw it on the screen, immediately I identified the classism and racism in those quotes. And I think in the context of a white supremacy and violence symposium, it was probably easy for many of our viewers to identify the racism and classism in those quotes. But it really drives home how this ideology lives in all of us, how even if we are not in a group that holds power, that we can internalize these things. All of us can internalize this ideology. And just really wanting viewers today, attendees today, to reflect on, if we were not in the context of a symposium about white supremacy, would you have noticed that racism and classism were driving those comments and ideas and attitudes in some of those quotes? If this was a conversation with a coworker, a friend, a family member, because there were not overt racial epithets or stereotypes within those quotes. So just really challenging people to think about that. And I know that I would identify that in a conversation, but also living as a Black person for 30 years, you become attuned to identify these things, even if they are coded. And I'm just also thinking about Grandmaster Jay with his coalition and his arrest and being removed from society for 7 years and then being surveilled for an additional 3. And what that brought up for me was this notion that even if we do everything right, he organized with police officers ahead of the protests. Even if we do everything right, it still is not enough. It still does not protect us. And it reminds me of police brutality cases, of people saying, oh, well, you should just comply. And I think about all of the instances of which we did comply. We were minding our business. We were just living our lives. And that still was not enough to protect us from the harm of white supremacy. That's what I'm sitting with.
I appreciate hearing that. I think Dr. Blocher raised that question in the last panel when he said, would armed Black persons be treated similarly as their white counterparts? And I'm so glad that you raised that, because 7 years with 3 years probation, it just again speaks to a very flawed judicial system. Much of what we talked about, and even how his organization is named as a Black militia, right? And a Black nationalist militia. And what does that mean in the context of so many others that we've seen?
Can I add something?
Please.
Actually, listening to you say that reminded me of something else that came up for me today in this question that I don't have an answer to. But what is the risk that we run by allowing anyone to have a claim to legitimate violence when we live in a society that has been founded on the ideology of white supremacy? We heard a lot about the state maintaining a monopoly on legitimate violence. But when that state is also carrying out violence on people that predominantly are Black and brown, is there such thing as legitimate violence? And are we creating a permission structure for this type of violence to exist, even if the state maintains a monopoly on it? And that's something that I'm sitting with and thinking about.
Thanks, Janelle. Josh,
Yeah,
what are you sitting
I'm
with?
sitting with, first of all, just being thankful to be in the studio with both of you today. It was really meaningful. We learned a lot, we listened a lot, we shared a lot, and I'm very, very sitting, first of all, with being thankful to be in the community with you today. So that's number one. I'm sitting with some of the same things that Janelle brought up. You know, we when we saw those examples that Janelle mentioned from Ray, right? You know, it's important. It reminds me that as much as we talk about systemic racism, it's still personal, and we need to fight racism in our personal lives, on ourselves, in our personal lives, and then we're in those opportunities to say something in those conversations, to have the guts to go ahead and do it, even if it's uncomfortable, and that's how I think that's how we make it in our own lives as well. So I think that was something that was quite important and to me as well. I thought that Professor Philandra, I think that's how you pronounce it, was the fear and intimidation she talked about elected officials. It's so sad that it's having a powerful effect, right? Like 10 years ago, we tried to warn people about this in my book. I hope we wouldn't get to this point, but we are at this point. And that means that firearms and the threats are having a terrible impact. And that means that the types of policies that we want and that can safeguard people and that are anti-racist might not get done because of people with firearms. And I think we have to realize that we got to turn that around. I think that's something incredibly important. Dr. Angela Stroud really spoke to me a lot when she talked about open carry as a new phenomenon with profound consequences. And someone who spends a lot of time in state legislatures, and I've had to walk through gauntlets of people with guns. In fact, I've been in hearing rooms with people with guns. Once a guy turned around and hit me with his sidearm, and I was like, oh my God, that's how close it is. And so, that's open carry is having that kind of effect, and it's intimidating and affects our democracy. And I really like the call of action saying, let's not normalize open carry. Like, we shouldn't do that, and I think we should fight back. This monopoly of force issue that Janelle brought up, I thought a lot about this over the years. And, a state, that's part of what defines a state. But at the same time, if you have racism imbued in those that are carrying out that violence, you just can't be just. And so it reminded me of the need to make sure that we do everything we can to root out racism in our law enforcement, in our military. And that's what it struck me. It's like that hit me really hard on that. The Estoppel by Nonviolence, the article from Daryl Miller was just incredible. And I just want to call out the profound sacrifices of people like John Lewis. To be able to do that, what they did on the Edmund Pettus Bridge, to be able to have hot coffee poured on you and realize that they were doing something in pursuit of justice, the enormity of the sacrifice struck me today. And especially because Daryl Miller was saying that actually got to change. It's a really important change. So they made progress, but the personal pain and sacrifice struck me today as something. It was just we owe them such a debt. That's where I will. That's where I will sit there. And I want to sort of leave today by thinking about one of the products that we produced last year, the Defending Democracy Report. Our center is going to. Is going to do a new version based on a lot of what we heard, what we heard today, and I'm really interested in the updates. I mean, one of the things that I think is incredibly important is that we're going to. I think we need to make sure that we're saying strong language about open carry and concealed carry, strong language about fighting back against militias. Those are things that I think are going to be important, and we're looking for what those recommendations can be, and I think we heard a lot of them today, and I'm looking forward to everybody's input as we move forward. So this is the beginning of a dialogue. We heard a lot today, and I want everybody who's here to feel free to use that email box to say, what do you think would defend democracy? What should we be talking about? Because here, at the Johns Hopkins School of Public Health, we do have a voice, and we want to release this new information in a blueprint for protecting our democracy, and we need to hear from everybody on that. So I think I'll end there.
Yeah. Thank you, Josh. I agree in terms of your defending democracy approach, and we absolutely want to hear from our viewers and those of you who've participated with us today on what are some of the things that we should do. I want to go back to your point regarding John Lewis and what Darren Miller said. One of the things that he was very clear about is that we need to protect what our ancestors have fought for. And I think that was his exact quote. I'm going to just share for briefly, probably 30 seconds, what is sitting with me. And it may feel really heavy, right? And I say this from the place of being here in this space and in this community with all of you. But I am sitting with the overarching question of who gets to live. Who gets to live and who gets to be, and who gets to be safe in this country. And I want to acknowledge PJ, and I want to acknowledge Jai, who are in the background working with multimedia, but have been in this space as two Black men, literally with us in space and in community today. And they are off camera, but certainly thinking and hearing the data and understanding the stories and hearing what has been said from much of the research that has been done. And still recognizing, to your point, no matter what you do, even if you do it right, the judicial system is such that looks on men, particularly men of color, in ways that are not equal, in ways that are not just. And I say that as a participant. I say that as a mom of two Black boys, and thinking about what does that mean. And one of the panelists raised the question of the historical construct of Black masculinity and how it shapes the views of others, right? And so what is my role as a mom in ensuring? So I'm sitting in this space, and I heard your comments, Janelle, about using the power of what we hear and learn, but also taking a step back and recognizing the importance of taking care of self and being able to be mindful that we carry, as you said to us much earlier, we carry this with us. So we will use the tools that we've heard today to be advocates and to be practitioners and to be policy focused and to be implementers in the space of what is just and what is right for all communities and all communities of color. And for all of us in this work who are sharing and shaping the way that we proceed and the way we think about how we address white supremacy in this country.
Thanks, Michelle. What you shared really reminded me of a quote that just hit me that I saw a few weeks ago from Dr. Monifa on Twitter. And she said that peace is a form of generational wealth.
Absolutely.
And it was just so profound. The peace to not expect violence when we go out and just try to live our lives. The peace of not having to worry about our family members not making it home.
Absolutely.
It really just stuck with me, and it just really resonated, and what you shared really resonated as well. So again, I think something I come back to is that we can't do this alone. I'm grateful for our ancestors. I'm grateful for people like John Lewis, but it's going to take all of us, not just the people who are being oppressed and harmed, to make the change that we need to create a future in a country that is free from white supremacy and gun violence. And so that is our call to action. What a day, what a charge, but thank you so much for joining us for what was an informative and illuminating day. Take care.